record on this. Right. Okay.
Just to ask, do I need to mute and unmute myself, or will I already be unmuted and muted? No, just stay on. No, okay, it will happen as, yeah.
Yeah, I think it's easier if both you and Daniel and potentially Richard would just stay off mute the whole time, unless there's background noise that's interfering, but
Sure.
I can't hear anything at the moment.
Okay.
There's 8 in the waiting room, so Richard, just let me know, 9, when you want me to let people in.
Well, it's not, John, you're doing the housekeeping, aren't you? You're on mute. John, you're on mute, but I mean, it doesn't matter, but I thought you as the MC.
Yeah, no, that's fine. Yeah, no, I'm happy to.
Shall we roll?
Yep. Shall I let people in?
Morning, everyone. Thank you for joining us. Welcome from the Roots2Justice team, and we have Lucy and Daniel with us. I was just going to ask that if possible, I'm just going to do a bit of housekeeping briefly. Ask for everyone to turn their cameras on, just to notify you that this session is going to be recorded and is going to be made available on our website in both English and Spanish. Please stay on mute, so there's as little interference as possible. And the other thing that we wanted to acknowledge is that the session will be in English, and that's not going to be everyone's first language. And we will do our best to speak clearly. And please do post questions that you have in relation to the session in the chat. And we'll be monitoring those, and we'll use those at the end in the Q&A session. I'll hand over to Richard. Thank you.
Thank you, John. Yes, I'm Richard Lord, and I'm one of the founding members of Roots2Justice, of which we're very proud, and a very warm welcome to all of you to this, our Roots2Justice Taster Session on free, prior and informed consent. And well, what are you tasting and what is Roots2Justice? I don't want to take up time describing this myself, but prefer that we get on and you can listen to and participate and experience it yourself, and be part of its creation. I'm using this language because although some of you may just wish to listen to this session, Roots2Justice is a legal empowerment project, which at its core has the notions of collaboration, inclusivity, participation. We hope you'll all share our views on the importance of corporate accountability, but this is about one particular aspect. It's about dealing with the realities and practicalities of legal intervention by environmental and human rights defenders in the global south, particularly in relation to business and human rights. We'll be having a number of sessions in our program and as part of our best practice forum on different topics within this broad subject. And we want to bring together players and participants from the north and from the south, and who all have different experiences and skills in these subjects and interests, and allow a learning exchange on them for the benefit of all of us. And we hope that all of you will be able to take away from this session something not so much of academic interest, but as a real practical value in terms of your situation, in terms of possible legal solutions to familiar problems, and that you will all contribute with your own thoughts and experiences. Well, why do we call the initial sessions taster sessions? It's partly so that all involved can have a taste of what this involved, but they're also tester sessions in the sense that our program is not all about what we think it should be, but about what all others and those of you participating think is most useful and most relevant. As part of our program, we've picked topics that we think are of particular interest and relevance. We've been lucky enough to have the benefit of expert panelists on some of these issues that arise time and time again around the globe. But the project is a living one, not just to be shaped by us, but by the communities and defenders who we hope will be nurtured by it and will nurture it. And in saying this, we're conscious of a paradox that in one sense, one can't talk about these topics in legal abstract terms. Everything has to fit your own particular circumstances on the ground or where you are looking for legal solutions. But on the other hand, we find that time and time again, the same problems arise, and that often solutions devised or tried in one place, whether it be Cambodia or Colombia or the DRC, can be adapted in others. And perhaps even more importantly, we hope that local lawyers working at a grassroots level can supplement their considerable local knowledge and skill and courage and resources with international perspectives and the possibility of taking action in places other than where the harm is occurring. So we hope you'll find this session and indeed the whole program and forum worthwhile and continue to be involved. And it'll go forward in different formats as we learn and grow together. So without anything further from me, let me introduce with great pleasure our main panelists this morning. And we have, first of all, Lucy Claridge, who is Senior Counsel at the Forest Peoples Programme Strategic Legal Response Centre, and that aims to improve the availability and quality of legal support for Indigenous and other forest peoples to secure their rights and livelihoods. And also we have Daniel Kobe, who is Executive Director of the Ogiek Peoples Development Programme, which is an Indigenous-led organisation working to secure the rights of the Ogiek and other marginalised Indigenous communities in Kenya. And as you may be aware, they've both been involved in, the word is overused, but a genuinely landmark case, which we'll hear more of soon. So without any more from me, over to you, Lucy and Daniel.
Thank you very much, Richard, and thank you for inviting me to speak today on this quite complex but very important concept of free, prior and informed consent, but also for giving the floor to Daniel as well to talk about how it works or can be challenged, can be threatened in practice. So somewhat unusually, I'm going to start by just giving a question to the floor. And I wondered if people would like to pop in the chat box their understanding of what free, prior and informed consent is. If anyone can just pop a few ideas in the chat box, and then we can see who's getting there, who's on the right track, and where things are at. I'll give a minute or two. Don't be shy. Okay, so I'm not seeing very much come up, so maybe I should just move on then. So I think on that basis, John, if you could move to the next slide or two, and I think Daniel and I are going to have a dialogue. He will ask me some questions on FPIC in terms of the legal standard, and then I will ask some questions of Daniel in terms of how it's worked practically. So we do have a couple of comments. So we've got the right to give informed consent to any project that will affect Indigenous peoples, sincere consultation, I like that, with affected communities to receive consent, has to be free and prior before a decision is made. Yeah, very good. Exercise right to self-determination and their lands, territories and resources. Okay, lots of really important elements coming out there. Thank you all. But yeah, over to Daniel now to start the dialogue.
Thank you, Lucy, and thank you for the participants. Lucy, I think many people do not really understand what FPIC means. Can you please explain what FPIC means, or free, prior, informed consent?
Sure. So, John, you can move
Lucy?
to the next slide now. So, free, prior, and informed consent is effectively a safeguard. It is that a community has the right to make decisions through their own freely chosen representatives and customary or other institutions, given that they are largely Indigenous communities, and to meaningfully participate in decision-making processes that might affect their lands, territories, and resources. And this applies whether or not a community has a deed, has title for those lands or not. So moving on to the next slide, essentially the concept of free, prior, and informed consent is an international legal standard. As I mentioned, it's a safeguard. It is established and recognised in the UN Declaration on the Rights of Indigenous Peoples, UNDRIP, and it's also been cited by human rights treaty bodies and courts and incorporated into other international standards. And it essentially comes from, as someone recognised in the chat box, the application of various human rights, including the right to self-determination, which is very key and crucial to the notion of Indigenous people's rights, the right to culture, the right to property, and the right to non-discrimination. And yes, as you recognised in the chat box as well, it allows Indigenous peoples to give or withhold their consent to a project on their territories or which may affect them. And prior is so important. It's prior to the approval of any project. So a project should not go ahead in any way, shape or form. And that includes even planning a project before consent has been given. And consent can be withheld, as I've noted, and it can also be withdrawn later on in the process if something changes or if the effects haven't been appropriately considered. So it's an iterative process. So therefore, it requires that communities can negotiate a fair and legally enforceable deal if they want to, but also, as I said, they can say no to a project that doesn't address their needs, their priorities, their concerns. And it's in essence, it's a result of the fact that for some people, there is this very high degree of socio-economic cultural collection to lands and resources. So if there are activities planned on their territories that would risk compromising physical and cultural survival or integrity of that community, and that would be harmful, those activities can only be justified if the community has given free, prior and informed permission. So the community has agreed to that development and that use of their land or territories, and also knows the risks. Yes, Daniel.
Yeah, does it only apply to Indigenous peoples, or can it also apply to non-Indigenous peoples?
So I'll come to that in a minute. I'm just going to go through first some of the concepts in a little bit more detail. There isn't the time to cover all of this today, but I have given my slides to John and others at Roots2Justice, so they can share this afterwards. But just quickly to go through what free means. So John, if you can move to the next slide, thank you. So free means that consent is sought in circumstances that don't involve any coercion, any duress, any manipulation, any bribes, any other factors which might compromise the communities making their own autonomous decisions. And, you know, this can be anything from, okay, we will come and develop your land, but we will build you a school. And that can be seen as coercion, because obviously in a situation where some communities have been discriminated and they don't have access to services, that can be seen as some kind of bribe or inducement. Obviously, if that's all part of the negotiation process and it's all fully understood, then that can be part of the negotiations. But it can't be seen as if you let us use your land in this way, and we will build you a school, and that's the end of it. So it needs to be very, very clear that communities should be allowed to make their own decisions. And then if you move to the next slide, John, this means that it's a fully participatory, inclusive process. Information needs to be communicated at the very beginning. There shouldn't be any intra-community division. And again, this is going back to the point about building a school in return for use of land or land being developed. Some community members might be very keen on that, so might sign up, but it has to be the whole community that agree. And there has to be time and space for this as well. So it very much needs to be fully participatory and inclusive. So then just moving on quickly to the next slide to look at what prior means. We talked about this at the very beginning. It must mean that consent is sought at the earliest stage possible. And this can take some time. In fact, it could take months, it could take years. So FPIC timescales and deadlines must be long enough to allow for that, to allow for communities to absorb and discuss information, to receive the original information, to go back and discuss with communities, community members, to come back and ask questions. Again, it's an ongoing iterative process. And the community themselves may be divided, so they need to come to according to their own institutions and how their own decision-making process, they need to decide what they want to do. And as I said, you know, it may be that a company or the state want to develop in a month's time, but that frequently, usually, regularly is not long enough to give prior notice. It can take quite a long time. So looking then at what informed consent means, this means that the community must have all the information. It's not, you know, they must have access to all the documentation, and it must be presented in a very fair, impartial way, not kind of, you know, in terms of marketing, not in terms of look at all the benefits this will bring to you. You know, look at all the modernization that this will create. It needs to be done, you know, in advance of any meetings, and it needs to be accurate and understandable. So that means it needs to be, translation might need to be facilitated as well. And obviously, you know, some communities may not be able to understand all the information that is put forward to begin with. So there may need to be some advisors, whether it's legal advisors or technical advisors, that are allowed to attend meetings. And they should be the community's own advisors as well. They shouldn't necessarily be advisors of the state or advisors of a company. So then just to move on to the concept of very quickly of consent. So as I said, the community can agree or they can decline to agree. And all the consent process needs to be in good faith. All views need to be accommodated, and there needs to be, you know, the atmosphere needs to allow good faith dialogue, so that everyone should be respected, there should be mutual respect, full equitable participation. And yeah, as I mentioned, that you can have access to legal advice, impartial legal advice, not a state or government company appointed lawyer. So yeah, essentially all measures should be taken, so communities themselves can decide who their community is, what their decision-making processes are, and ensure those decisions are not taken by others. Quite often what happens is a company or a state will go to one member of a community and obtain free, prior and informed consent, or consult with them, and then they'll get a document signed off and say, right, we got FPIC, or right, you know, we consulted with the community. And that's not sufficient. It needs to be for the whole community deciding through their own processes. And that all relates back to the right to self-determination and culture. So Daniel, back to you. You had another question for me. Thank you.
Thank you, Lucy. That is very, very well covered. I'm just wondering whether, does it apply only to indigenous peoples or also non-indigenous people?
So essentially, it's a collective right, a collective safeguard, which belongs to the whole community. And yes, it largely applies to indigenous peoples. As I mentioned at the very beginning, it's highly woven through the UN Declaration on the Rights of Indigenous Peoples and in lots of the related standards and jurisprudence, particularly within the Inter-American and the African regional human rights systems. However, there are occasions when it can be applied to communities who might not perhaps be seen as indigenous, but those will be communities who have very strong attachment to territories and resources. And a particular example of this is a case called Saramaka against Suriname, which was an Inter-American case concerning an Afro-descendant, what's called a tribal people, and that term comes from the ILO Convention 169. Essentially, the primary condition here to which the need for free, prior and informed consent was linked was the strength of this community's collective attachment to their territories and resources, which showed that there would be a very severe level of harm suffered if that attachment to the land was severed. So as I mentioned, they aren't strictly an indigenous people, but they did have this they do still have this very, very strong attachment to their land. So they're called an Afro-descendant community, but largely it only really applies to indigenous communities. Thank you.
Yeah, Lucy, mostly when people discuss about FP, does it apply only to companies or also with governments?
So essentially, obviously states have an obligation to protect, to respect, to fulfill human rights protections, and that applies without discrimination. So obviously it applies to governments in the sense that it's woven through not just under it, but also many of the other rights which apply to indigenous peoples, which we discussed at the beginning. So property, non-discrimination, culture, self-determination. In relation to companies, the UN guiding principles on business and human rights are very clear that there is a duty in relation to human rights due diligence standards, and that process should be initiated as early as possible in the development of a new activity or relationship, given that human rights risk can be increased or mitigated already at the stage of structuring contracts or other agreements. And they may be inherited as well, where there are mergers and acquisitions. So essentially, there is a duty on states, but there's also through the UN guiding principles, companies do have arguably an obligation to take free, prior and informed consent in as a safeguard, and the rights of indigenous peoples take them into account when they are proposing to engage in a development process or project as part of their human rights due diligence processes. Thank you.
Yeah, that's great, Lucy. When somebody wants to know how is it in practice that FPIC has been applied, or how is it working, because people might not really see that this is FPIC and it has been applied. So how does it work?
So essentially, it's as I said, it's a safeguard. So it's there to ensure that there's a very level playing field between communities and the government or companies. And where free, prior and informed consent hasn't been sought as part of a development project, that can create really big problems, particularly for companies later down the line. So it will obviously provide companies with a much greater security and less risky investments. So there is a financial interest, I think, on companies as well, to ensure that FPIC has been the FPIC standards have been met. So there really need to be careful participatory impact assessments prior to any development, and then ongoing throughout the process as well. As I said, it's an iterative process, and communities can withdraw at a later stage. So through project design, and also there should be agreements in place if needed for any benefit sharing. So if there's going to be particular benefits that flow from a development, then communities should be able to share in the resources that result. One of the problems with FPIC is that it's obviously a standard within international law, and it is respected within some national laws. But FPIC, sometimes only national laws are followed, and the standards aren't woven into national laws, and that's where this conflict can arise. But obviously, as I said, because it's a standard in international law that should apply in various settings, then it still can be relied on. So passing to the next slide, John. I think another thing to say is that communities really must be in the driving seat here to prevent any power imbalances, and that's kind of woven through this idea of free and particularly and informed as well. So a company or a state is the one that should provide those conditions to ensure that they can maintain that position in the driving seat. And as you mentioned, Daniel, unfortunately, one of the ways that the FPIC is not complied with is often that companies or states contract or issue permits before FPIC is obtained, with detrimental and harmful effects on communities' rights, interests, and lands and natural resources, and that can be a real problem. Thanks.
Yeah, thanks, Lucy. We know very much that most companies or governments sometimes do not apply FPIC. How do we challenge such where FPIC is not being complied on?
So there are lots of ways, and I don't think there is a kind of one size fits all response here. Obviously, the first thing to do is to get some legal advice, for a community to get some legal advice as to what the standards are in relation to national law, and how international law can relate to that, and what international standards apply as well, depending on what international law a particular state has signed up to. I mean, the first thing is to engage in some, once you've got an understanding of the legal position, is for a community to engage in some advocacy with a state or with a government, and to try and enter into some kind of dispute resolution. And sometimes there are various bodies that can be used. So, for example, if it relates to palm oil, there are regulatory standards. If it relates to financial investment, for example, for the World Bank, there are regulatory standards. Another option, obviously, is to use litigation. So that can be sometimes within national courts, relying on an international law where possible, weaving that in. You can also use regional or international litigation, although to access those avenues, often you have to go to the national courts first. So those are some of the remedies. I mean, I guess a kind of a first port of call for communities perhaps to come back to an organisation like Roots2Justice and seek some advice, and they can, you know, pass that on to lawyers and others that they work with, or organisations such as ourselves. I just wanted to mention that one other thing, which is that free, prior and informed consent, as established within the object case, your case, Daniel, which we'll come on to talk about in a minute, also applies in relation to remedies. So in this African Court of Human and People's Rights ruling, this related to a case against the government of Kenya, the African Court declares that the Kenyan state must take all necessary legislative, administrative or other measures to recognise, respect and protect the rights of the object to be effectively consulted in accordance with their tradition, customs, and or with the right to give or withhold their free, prior and informed consent with regards to development, conservation or investment projects on Ogiek ancestral land, and to implement measures that would minimise the effects of such projects on the Ogiek survival. So this essentially relates to a case we'll come on to discuss, but the African Court issued remedies in relation to human rights violations that took place against the Ogiek. Whilst the Kenyan government is making those remedies, the Ogiek's right to free, prior and informed consent, needs to be respected within those remedies. So it's once you get to the point of reparations, free, prior and informed consent will apply then too. So I think that's probably enough for me, and I think it'd be really good now to hear from you, Daniel, about some practical ways that FPIC has applied to your community. So maybe let's pass over to you then, Daniel. Please can you tell us all about the Ogiek? Can you introduce them and explain who you are and where you're from?
Thank you, Lucy. Yeah, it's unique to have people interacting, asking questions. Thank you very much. First, I'm Daniel Kobe from the Ogiek community. I was brought up in Mau Forest Complex, which is one of the Ogiek areas in Kenya. We are situated almost 150 kilometers away from Nairobi, for those who have been in Kenya. And the Ogiek community has a population of around 52,000, and we are within 7 counties. But for the sake of today, I'll be discussing specifically on around those who are within Mau Forest Complex, which is an area of 400,000 hectares, which has a claim of the Ogiek community. And personally, I've been brought up from historically hunters and gatherers background. And I had among those who went to school, and that's how maybe I'll be able to discuss a lot about the Ogiek community. Back to Lucy.
Thank you. So I talked very briefly about the Ogiek and the case that you brought to the African Court. So I know that you've been fighting land dispossession for a number of decades. Can you talk a little bit about that and the extent to which FPIC was included in it was a safeguard that was respected or not within decisions around your community and around your community's land?
Sorry, Lucy, I almost lost your question. Maybe come back.
You've been fighting land dispossession for a number of decades. Can you talk about what happened and the extent to which free, prior and informed consent was met as a standard within those struggles? Oh, I think Daniel might have frozen at the key point. Just as he was about
Sorry, we have connectivity issue.
Okay.
Able to fully. I don't know if you are able to hear me. Are you able to
can-
get me?
I can hear you, Daniel, yes. So just to repeat the question, I hope you can hear me. The Ogiek have been fighting land dispossession for many years. Can you talk a little bit about the challenges you faced and whether or not free, prior and informed consent was respected within the way that the Ogiek have been treated? I think we're losing Daniel now. Sadly.
Well, Daniel, yes, it seemed to have disappeared, which is really unfortunate, as Lucy said at the key moment. But while we're trying to reconnect, Lucy, I know you're not supposed to ask the questions and answer them, but you obviously have an intimate knowledge of the case. So while Daniel is in a communications hole, perhaps you can continue and hopefully we can reconnect. And I put the question in the chat for him.
Great, thank you, Richard. So as soon as Daniel comes back on, I will pass back to him, because I hate to speak for a community I'm not a member of. But essentially, I've been working with the Ogiek community for the last 13 years. They are, as mentioned, they're a community of around 50,000 who live in Kenya's Rift Valley. And over the past 100 or so years, they have been dispossessed of their land, evicted, relocated, and marginalized and discriminated during the colonial years, and then that continued post-independence. The reason for the ostensible reason given by the post-independence government was the need to conserve the Mau forest where the community live. That is their ancestral land, and it's the land with which their livelihoods and their identity is very, very closely linked from a cultural perspective as well as an Indigenous community. And at the same time, the Ogiek community members have also been evicted to allow for land to be passed to other communities to gain political power, to gain political votes, and there's been a huge amount of logging that has taken place as well in the area. So the government's ostensible reason to argue that the area needs to be conserved and the Ogiek shouldn't be allowed to live on their land, can be taken apart quite easily. But within all of that, the Ogiek's, I think it's fair to say that the Ogiek's right to free, prior and informed consent has never been sought. They were issued with eviction notice, for example. When I became involved in 2009, they were issued with an eviction notice, and they gave them a month to leave their land. And that was kind of the last straw, having been through long advocacy processes within the Kenyan state, having also litigated within the Kenyan courts unsuccessfully, or cases which lasted 13 years and were still pending at that time, never resolved. So they resolved to go to the African Commission on Human and People's Rights, and that's where I became involved. And then the case was referred up to the African Court of Human and People's Rights, and there was a merits judgment in the Ogiek's favour, concluding particularly that their right to free, prior and informed consent had been violated. So that was issued in May 2017, and then there was a subsequent separate reparations ruling, which was issued back in this summer, in June 2022. And within that process, as I mentioned, the community are entitled to various reparations, including return of their land, full recognition as an Indigenous community, compensation for the damages and loss that they've suffered. But that process itself needs to be conducted in full consultation with the Ogiek. Daniel, it's great to see you back. I have just been talking at Richard's request a little bit about the Ogiek struggle before the court. Can you hear me now? We can see you. Can you hear me, Daniel?
Yeah, I don't know whether you can hear.
Yes, we can just about hear you. I have talked a little bit very briefly about the journey to the African court and explained the merits and the reparations judgment. But if you can hear me now, maybe can you describe what the successes have been within that legal journey going to the African court?
Daniel, it seems you can't hear us, but obviously if you can, or there's a way in which we can patch you in, we're very much interested in hearing from your wisdom and experience. If not, I think that we must carry on as best we can. Either, I think, and again, we can maybe get some consensus on this, but either, Lucy, you may want to carry on giving us the benefit of your experience, or we move on for a moment, some questions, some observations from those coming, because I suspect many of those on this call will have their own experiences of challenges, successes, problems, obstacles with this notion that sounds wonderful in theory, but we all know is difficult to implement in practice. We'd much rather be hearing this, of course, from Daniel, but if technology doesn't allow that, we must do the next best thing.
Absolutely. Let me try one more time. Daniel, can you hear me now? It's fine if we can't see you. Obviously, we prefer to, but if your connection is weak, then that's fine. Can you hear me now, Daniel? I'm thinking that's a no. So maybe shall I turn to some of the questions in the chat box? So the first one, I think.
Yeah, well, Lucy, there's a question which is, would you, and I'm just reading it off the chat, would you recommend that FPIC is extended to local communities in addition to indigenous peoples? And just to add a gloss to that, I suspect most people who represent indigenous people would recommend, and other communities who are under threat from customary lands, would welcome its extension as far as possible. But is there a legal environment that allows that? And I know that may be very country specific, but perhaps I can stop talking and ask you to answer the question.
So yeah, that's a question from Tamara. Great. Hi again, Tamara. Great to see you here and be in touch again. This is a really tricky one because the right to free, prior and informed consent is so clearly linked to the close relationship that indigenous communities have with their land, that strong cultural attachment, their livelihoods, their very identity. I think that there isn't a legal basis for it, I don't think, within in international law. And I don't want to speak for indigenous peoples themselves, and this would be a fantastic question actually for Daniel to answer when he comes back. I think though that there would be strong pushback from largely from the indigenous community, because this has been a, getting recognition through other standards has been a really hard journey for indigenous communities, and I think for that right to be extended to other communities perhaps doesn't have the basis in law, but might might not necessarily be what Indigenous communities would want as well. And that's why I say it's quite a controversial issue. I mean, if you look at the standard as a kind of the ultimate standard, in theory, yes, it should be that the standard that everyone follows through environmental impact assessments, etc. But to say that it could be extended to others, I think is tricky. And yeah, it would be good when Daniel comes back to actually ask his view on that as well. I think there was another question from Shirley Shipman, Richard. Says, are there problems in ensuring that every
You're on mute, Lucy.
Sorry, someone just muted me. Are there problems in ensuring that every community member is involved in the decision and that all voices within the community are respected and considered? It's clearly not going to be an easy process, but most communities do have effective ways of organising themselves, and that's what I mean by it can be quite a long process. And I guess it's up to a community to decide how they want to reach decisions, who's going to represent them, who is how they, as I said, how they're going to reach consensus and who's going to speak for them as well. And that, as I said, that can be quite lengthy, but it's an iterative process as well. And there are obviously quite a lot of examples where one or a few community members purport to speak for the whole community. So I think when a company or a state is engaging with the community to seek FPIC, they need to make sure that those they are engaging with do have the support and the ability to speak as representatives of the whole. And that means perhaps if there's a community in various different locations, it might mean going to all the different locations. I mean, there are issues here, I guess, around gender as well, and ensuring that women have a role in speaking, and that women often, in some communities, men may be more outspoken, but there isn't an issue of communities of companies or governments making sure that they do go and speak with women as well, and making the effort to do that. Daniel is back, so I'm going to Richard.
Why don't great that Daniel's back, and there's some also really interesting comments from the participants, but perhaps we can try the question once again, Lucy, and Daniel may be able to hear it and respond to it. But thank you for your comments, and we will very much open up to other participants before too long.
Sure. Daniel, can you hear us now?
Yes, I can do, yes.
Okay, perfect. So we've had a brief interlude while we addressed a couple of the comments, and there is a question I will ask you in relation to one of those comments as well. But so I talked about very briefly the African court process and the merits and the reparations judgment. Are you able to tell us a little bit about the successes of your community's legal journey?
Thank you, Lucy, and thank you for participating. I'm sorry for the internet connectivity. Really, the Oge community, as Lucy might have told you, we have been in court for close to 20 years. And one of the greatest successes is really trying to bring together the community, right? For them to understand what really it means to go to court. One of the greatest issues which we faced was first to interpret the process of being in the commission, African Commission, and also being in the African court. So for them to be able to say, we accept to go to court, having been in Kenyan court for close to 12 years and being in the African Commission and the African court for 8 years, And then after the win on the 26th May 2017, there was again, there's been always another delay on the issue of implementation. And also whereby the government of Kenya decided to withhold or rather deny time or process of going to court, of course, using COVID as an excuse, which took a bit of time until the 23rd of June 2022. That is where the reparation judgment was made. But for the community, that period of holding the people together, to be able to weigh the patience, to be able to understand what it means, and a lot of violations, even amidst going on, get a lot of mechanism where they use this thing, and then also allowing them to understand that what is happening in court and what is happening, and also being interpreting most of these legal jargon sometimes, even in our own language, to be able to help them to understand the journey. So, and also the good relation we had with our legal team also helped us, because many a time we bring our legal team to come and interpret some of the issues which we may not be, which we were unable to interpret to them. And also giving them clear examples of those who have waited our time. And I used always to tell them about Nelson Mandela's being in there for 27 years and the rest, and allowing them so that they can make and say, oh, if they waited for 27 years, so we are not yet 27 years, we are within a given time frame. So all these, and also we came up with also a strategy of allowing women and youths to understand the case. And we had a very strong support from the women in terms of they would convey messages through folk songs, they convey through a lot of issues without sometimes even addressing people, but the folk songs and the way they were supporting us, those who are leading. And then later on, there were some questions from the youths. The youths were saying, oh, you are fighting for this land. You are not telling us what you are doing. So we said, there was a gap here. So we started involving the youths, and they started using social media. They started Facebook, Twitter, and the rest. Now, and previously, we used to have a challenge because the youths were feeling we were doing things against their wish. So that kind of link and bringing everybody on board helped us to continue with the journey. Back to Lucy.
Thanks, Daniel. That's really good to know. Can you tell a little bit about the community's free, prior, and informed consent? To what extent was the Ogiek's free, prior, and informed consent sought prior to all the evictions and the land dispossession, and what issues did that create?
Lucy, that is a sad question to answer, because when you say first for the Kenyan government to accept FPIC is a tall order, because one, they don't accept the use of the word free, but they like using the word prior informed consent. So for them, they want to use the word to remove F and add PIC, because they believe only in the terms of consultation instead of consent. So the mass violations we have seen, eviction, which was becoming a perennial way of doing things, it would never really got us, or rather they never at any time try to use, in fact, impose, including most recently, even after us winning in 2020, 2021, they could still say, no, we want to reorganize. We want to see how we can settle Ogiek people, and telling them, we want to give you 5 acres. And yet we had asked for a community title. So they didn't seem to understand that we needed the communal title, but in them they thought they should just go the way they think, or the way the Kenyan, the way they have already structured their thinking without the consent of the Ogiek community. So in other words, there was no consent. Everything which has been done has no consent because, in other words, even the self-determination of the Ogiek community, and you know the Kenyan government also didn't sign the UN DRIP. This also makes it very, very unusual. And we have been trying to push using our means to have these Kenyan government accepting the issue of consent.
Thanks, Daniel. And yes, I mean, it's very true that the Kenyan government did not agree to UNDRIP when it was adopted. Interestingly, though, the African Court very specifically referred to UNDRIP as a relevant legal standard in both its judgments. So it didn't see that as a barrier because UNDRIP is seen as a set of standards around the world and internationally, and because there are so many other states who were there when it was adopted. Daniel, what would you advise a community facing similar challenges to the ones that you have been facing?
A good question. Most of the communities, first is to let them get the right legal team. I always don't tell them, but I always tell them, get the right people to advise you on issues related to the violations or the challenges you have towards your land and territories. And when they have understood that, is to reorganize themselves and ensure they do thorough research on the issues which are facing them. Because sometimes people rush to court and yet they have not done proper background to really support with evidence. And then to see that they have also exhausted, especially for those in Africa, to exhaust their legal or domestic legal system before going to the regional courts. And when they have done that, they also have to continue updating their communities. One greatest challenge I have faced, and I've been advising many African countries, communities rather, who have been visiting us, trying to learn from Ogiek, is to tell them, let them have the blessings of the communities who they are representing. Because sometimes if you go and then you go to court and then you ask the communities, they don't know what you're doing. And then you say, I'm representing a community, and yet you don't have their consent or you don't have their backing, you don't have their support. So in this case, it is very, very important that you bring the people to understand and give feedback every moment about what you're doing. Because sometimes when you create a vacuum for not telling people what is happening, and all. Hello, are we together, Lucy?
We are, yes, we can hear you. You cut off a little bit there, but you're back. Please go ahead.
Yeah, it's good also to update them and tell them it might take a bit of time. And it is also good to discuss on that it can also be expensive, costly in many ways. So they should get themselves involved, because it's not that in all time you get maybe pro bono services like some of the people like Lucy, who gave a bit of their time and outside the normal. Sometimes you might get where some of the legal team might also need a lot of money. So you should also prepare the community on all these, because the moment you begin to say, oh, somebody will help us to do it, and then the people feel they cannot do it, and finally, I come back to the research. I think part of the reason for the success of the Ogiek case is a lot of research work was done and background, and of course there were facts about that the land belongs to the Ogiek. But we had to prove beyond reasonable doubt that how is it? We use videos, we use people giving history, we use experts, even those who have done a lot of research in our land, to be able to prove that indeed the land belongs to the Ogier community.
Thanks, Daniel. And I think maybe the last question, is there anything you would do differently in the case or in the work with your community?
Yeah, I think from the gaps which I noted over time is that sometimes you ignore a given group within the community, which later on become the people who will be against what you're doing. So it's always good. And one other thing is that never ignore the youths, never ignore the religious groups, especially in Africa. Religious grouping are very, very strong. And then also women, you should always ensure women on board. Don't depend only on the so-called leaders, community leaders. Because the moment you do that, the people will begin to say, we even don't recognize those leaders. So if they say that, and then these are the people you are depending on, then you are done. So the best thing is let the people who you also have, they have a level of support within the community, or they can be supported within the community. Who will be good allies? They'll be the people to speak to the community on your behalf, because you may not be able to reach 45,000 a year alone. So there are even some of the Ogier who have never seen me or who have never met me. They might have seen me only on a photo. So for the people to be reached to, you must have the right people to work with. So those are some of the things which I always say should be done. And then again, involving other government commissions, because more recently, when the time of implementation started, I've been visiting many government offices. Some of them say, we don't know. We heard you won the case, but we do not have a copy. So I think it will be good to have updates to that. Hello?
Well, Daniel, we can hear you, but you've broken up a bit.
Yes, sorry, I am
now,
using my hotspot and some people are calling. I'm sorry.
Right, now loud
yeah,
and clear.
I was trying to come and yes, you can hear me. Yeah.
Now loud and clear, so please do finish your answer.
Yes, sure. So thank you. I will have wished to finish earlier than that. Really, the issue is that kind of system is what we are trying to promote so that we don't have a lot of challenges when we are doing the case. Thank you very much. And I'm sorry for all sorts of interference.
Daniel, you needn't apologize. We understand the challenges and the frustrations, which must be very tiny compared with the challenges and frustrations you faced with this case. And indeed, I sometimes think it's not so much exhaustion of domestic remedies, but exhaustion of communities by domestic remedies because of the difficulty of the process. But I think it's now appropriate, first of all, to thank, on behalf of Roots2Justice, Lucy and Daniel very much, because it's really invaluable to hear from people who've actually had these problems and been able to overcome them. Not perfect solutions, but a lot better than many people who end up with no solution. I'd really like to open it up to other participants, not just questions, but observations. And if it's not unfair to pick on people, I've got a couple of comments and questions from Floor Newt. And Floor, if you're still there and willing to speak, I wondered if you could provide any of your comments and thoughts on your experiences, and of course, questions to either of Lucy or Daniel.
Sure. Yeah, thanks for giving me the floor. Yeah, I had two questions related to also a case that we are working on, but also some other research that I've done in this field. And one issue that always comes up is the quality of the consultations in the FPIC process, and also the individuals actually conducting the interviews to kind of receive the consent. And in our experience, or at least in my experience, I haven't seen a process where that went well and where that was truly neutral, which of course is the intention. So I was just curious, as a question to the group, whether anyone has positive experiences with any of these external consultation companies, or has an example that is somewhat positive in this regard.
Thanks, Flora. And please do, well, you can put things in the chat, or please put your hand up, or we're a small enough group just for people to come in. I think I'll probably in trouble for saying that, but please do just come in or put your hand up and come in, because it's really important to all learn from the experiences of others on the group.
I was just going to say, I think it's a really, really good question. And unfortunately, I think I tend, and you know, others that I work with tend to get involved when FPIC hasn't been respective or the process has gone wrong. So it's actually quite hard to find good examples. But I think Wood has got his hand up.
Yeah, it's a little bit, well, I know Flora very well because we work at the same organization, but and actually Flora knows the example that I will be talking about, because I actually talked to her about it. But I was in Colombia, and then actually one of our colleagues was going through one of the free, prior, and informed consent processes, well, done by the business. Which makes it sort of a due diligence. I think the FPIC is generally done by the state, and then but basically it's pre-cooked by the company usually. So I don't think there is an ideal situation, because it always looks a little bit, and that's also maybe why Floor might not see it as a positive example, but it always looks a little bit like people are being bought off, no? Because there's always a little bit of quid pro quo. There's a situation where people need have their land, have rights to their land, and how does a company then organize that in a good manner to get a consent, and that is done by also basically paying them off, basically offering them positive things, money in general, for the process at least, to show also that they can have the consultation going, and that costs money obviously as well, and that also that they need to go into that process. And well, I saw that a little bit from close by, and I actually the people said yes in this process. So I would think that's the main thing about it, isn't it? I mean, if all the information is there, well, I wasn't 100% sure that all the information was there. It wasn't forced, but they sure knew that they were saying yes to getting money for a consultation process, and also that went in different stages, and then basically they only got like the last stage when there would be a yes. So in a way, I think it was probably not a 100% right way of doing it, but it was a way that looked to me like they had the right people there. They had people there that I trusted also to do the process well. And still there were a lot of things that I thought, well, if at one point like half of the village goes against it, then this is still a terrible process, and there's a lot to be done about it. I don't know if that answers the question a little bit, but it gives a little bit of insight maybe.
Yeah, it answers it partially, but also I think what I find the whole process itself, I find questionable sometimes when external people are flown in, and often the transport is also arranged by the project developer, for example, right? Or a state that has an interest in having a yes as an answer. So I'm just curious whether, yeah, are there guidelines for this process? I've looked for them, but I haven't found clearly any examples of which I think, well, this is a one that we could maybe showcase, this is how it's done, which would potentially be an example that takes a very long time, as you mentioned before, Lucy. So I'm just curious, yeah, to hear also from the group what their experience are in this regard, if you fly in external people for this very important element.
I've shared in the chat quite a useful a publication with looking at FPIC just now, a publication written by a couple of people actually who are at FPP or happen to be, but that might be helpful.
Thanks.
Yes, and thank you very much, both of you, for that observation. And I suspect there are many shades between an ideal situation, which I doubt many of us will come across, and something that there's nothing at all. Can I move on, because I've got some observations and questions from Paul. I'm not sure if it's Paul Ole in Tanzania. And if you're willing, maybe, Paul, you could share with us your problems and issues and what's happening there. And perhaps at the same time, I can throw out a question that's related to this, which is whether people involved have had experience of being able to invoke FPIC at a domestic level, because a lot of things we hear is where someone comes up and puts up a fence and says, right, you've got to move off your land for sugar or a mine, and someone says, well, what about FPIC? And they just say, well, we don't recognize that here. Whether people have had success at domestic level, but if people are thinking about that, perhaps, Paul, I could invite you to share your experiences or wisdom or questions, or all of them.
Thank you, Richard, and good afternoon, dear panels and members who have attended the meeting. What my brother Kobe and Lucy has been sharing, it came to my mind that I've just learned from their experience that what is happening in our homelands, my homelands, it is really a government forcing to remove our people from their ancestral land to a land which they are not their choice, but also intimidating and even killing and beating them. What is happening even now when we speak, there's a government team which is remapping the villages that have been demarcated, the land that has been demarcated. The teams are there forcing the citizen to agree on the government plan. And mind you, the land that has been taken, it is purely the land belonging to the villages. Those are the registered villages of the Ngorongoro. People who have been living there. They have been living decades and decades. I am a Maasai. I am born and raised at Ololosokon village. I am supported by the village to acquire my university study. So I speak with a lot of pain because I see the future of our people is in dilemma. And if the government today is going to remapping and register villages as new villages, where is our rights? We cannot get our rights. We cannot use the legal expertise to regain our right, because it will be new villages, new people registered in that area. Our Maasai people in Ngorongoro Conservation Area are not willing to go and live their beautiful land. They are forced behind. Many teams visited the government's prime minister, submitted a report. The government has never responded to any of our advice. We love conservation. We have been living with animals. We don't eat them. But now I think personally, and my people are also thinking, because we have been in coexisting with animals, that is what causing us a lot of problem. To me, I don't know. There are a lot of politics around, people saying we have not been beaten, no one killed, no one was injured, but those are my relatives. My home, my classmate are in Kisongo, in prisons, people I study together, people we live together. Guys, sorry.
Paul, thank you for sharing that. A very moving and profoundly disturbing, and indeed that accords with the video footages that I and no doubt others have seen from some of the evictions that have taken place. And I suppose the question for this group, obviously, other than solidarity and wishing to share your pain and your experiences, is there a prospect of legal redress? Obviously, going to court is only one weapon or tool in a toolkit combined with advocacy, politics, economics, and so much else. But I'd be interested in any response from Lucy or Daniel or any of the other experts and those with experience of this sort of thing.
Sure, Richard, I can respond to that briefly. And yeah, thank you for sharing. It is really traumatic what's happening in Tanzania at the moment. And I'm actually just back from the African Commission of Human and People's Rights session, during which the Tanzanian state representative took the floor and made a statement in response to something said by the chair of the African Commission, effectively denying that the Maasai have any connection with that land or have any rights over that land. So there's this denial is continuing, and in big kind of public official fora as well. But there are quite a few legal cases that are being taken at the moment. There was an East African Court Justice ruling a few weeks ago, which is being appealed. Some people may have heard about that. So that relates to the evictions which started in 2017. There have also been other cases which have been lodged since then, and I'm part of a group of NGOs who are working with various Maasai leaders to help them access legal remedy, but also wider advocacy and other assistance. Various UN special rapporteurs, for example, came out and made a statement when this all started happening in June, July, condemning the actions. The African Commission has made quite a strong statement as well. Conservation organisations as well, like IUCN, who are also, involved in the Ngorongoro conservation area, which is a UNESCO World Heritage Site, have condemned some of the actions as well. So I think there is quite a lot of awareness around this, and I know that Daniel, as a fellow Indigenous community member, has been assisting and offering solidarity as well. I don't know, Daniel, if you want to add anything at all.
Not really, but I been very much close to what's happening in Loliondo, Ngorongoro area, and we've been working with some of the HRDs. Some of them who have actually, they are now in Kenya because of the issues. I know Paul is aware, and OPDP, my organization, we have been working closely with them, and I have been telling them about their hearts not to die, but to keep on pushing. I think one day the truth and the justice will come to the Maasai, and because I know all these are politically instigated, and I think with time, with also the push from international communities, I think it's something will happen to really give justice to the Maasai of Ngorongoro. And as a matter of fact, I know most of the leaders are getting, some have been arrested, some have also died in the process. I know that it will come, and I know Lucy and some of the legal team across the globe are trying ways and means on how to push the Tanzanian government to give justice to the Maasai of Ngorongoro.
Thank you very much, Daniel. Time's moving on, and I want to give 3 minutes at the end so Emma can explain how we're taking all this forward and using the learning and the questioning, but that still gives us a few minutes for questions. And Shirley Shipman, I think you had a couple of questions or observations or both. Perhaps I can hand over to you.
Thank you, Richard. And these feel relatively, well, not weighty questions really, compared to what we've just been hearing from Paul. So it's a little bit hard to follow. And I just want to add that clearly, Paul, all of us really feel your pain in this situation. We're not in it. So we recognize that you're in it and what you're facing. My question relates a little to something that Flor was talking about, to do with process, I guess, and to just give a little bit of weight to my question. I want to briefly explain that my interest is in relation to consent, and I have quite an interest in mediation, and I have been involved in conducting some research with a couple of colleagues from Bristol and Essex in national human rights organisations or national human rights institutions, and how they approach dealing with individual complaints of human rights abuses, where there's a particular imbalance, because of course human rights abuse will have been committed by a state, and they have the power to deal with these in a variety of ways, but using particular forms of dispute resolution, which can be consent-based or agreement-based forms of resolution, such as mediation. And I've been in the process of writing an article on how we can deal with power imbalance in mediation processes. It's become very clear that the mediator themselves has a great deal of responsibility in ensuring the fairness of the process. And so the way that the mediator is trained to undertake that process or to deal with party imbalances is really significant. And in pursuing some of this, I've been looking at some studies on where power imbalances may arise, and was particularly interested in the power imbalances which can be caused because of cultural differences between those who are on one party to the mediation and those who are from a different cultural background. So particularly in Latin America, where the culture in terms of giving consent and agreeing and negotiating is very different to a Western culture. So the Western culture might go in with, right, this is we'll start with our negotiation at a particular point and then move up. So they might go in with the lowest offer, whereas the South American culture may be that they go in, what they really, really care about is getting the good relationship. And as a result, they may go in with a higher stake for them. And they lose out, therefore, in the negotiation process just because of where their starting points are. And the differences between what they're negotiating for and what's important for them in the negotiation. And therefore, there's a power imbalance created by cultural difference. And so one of the things that I've been looking at in my article is the difficulty of where you've got an individual who's so powerful, the mediator, who's responsible for the fairness of the process, and actually their lack of awareness of the cultural differences and how that can impact and create power imbalance in a particular situation. So my questions coming out of that, and I hope I've just given enough context to understand why those questions might be relevant here, is who organizes the consultations, who organizes these participations and this free, prior and informed consent process, and what background do they have in terms of ensuring that those processes are fair? Because we were talking about bringing in groups, and what training do they have? But also Daniel mentioned the importance of the community themselves having done research into what their claims are and their relationships with the land and the evidence, and being prepared to be in it for the long haul. But I'm just wondering, on the other side, the organization side, who's actually making sure that there's research done about cultural differences in terms of how negotiations might work or how informed consent might work? Because I think that may be something that's actually really, really important in terms of creating a fair and balanced process. I hope those questions make sense.
Surely they do, absolutely, and they're, I think, extremely important. And as a mediator myself, I'm aware of the importance of cultural differences and negotiating style. Unfortunately, they'll have to stay at least rhetorical, in the sense that I hope people will answer them offline, but we're running out of time. I'm going to hand over to Emma now, because I'll leave Emma to say it, but it's really important, if possible, this isn't just a webinar, good though I hope it is, but it's start of a process that you'll come along with us and help creating. So enough from me, but thank you very much for everyone for questions, observations, particularly to our panelists, and over to Emma.
Thanks very much, Richard. And really just to reiterate that, thank you for facilitating today, and to Daniel and Lucy for sharing your insights and your contributions, and for everyone else who's been able to join. I think John is going to share more links to Lucy and Daniel's work, so you can follow up with their projects if you'd like to. And as Richard said, this is the beginning of the Roots to Justice initiative, and the beginning of a series of webinars that we're planning to hold over the coming months. The next will be in the new year, and it will focus on gathering evidence, and we'll follow that with another webinar on international human rights standards as they apply to corporates. And those two are based on consultation that we've done over the past year on what really are the most pressing issues for some of the defenders in our respective networks. But this is all with a view to leading into a much wider best practice forum next year in 2023. And we will similarly be exploring some of these topics in more detail. So corporate governance, human rights, building a legal case, and using foreign courts, amongst others. But I've put our Roots to Justice website in the chat, so that has more information on some of those topics, and also how you can get involved if you're a lawyer, if you're an organization or network supporting defenders, or if you'd like to partner in some other shape or form. We'd love to hear from you and to talk with you in the coming weeks and months. I think, as Richard said, the aim of this whole initiative is to mobilize the international community and the legal community in particular, and to connect with wider alliances and networks. So we hope to be building those partnerships in the coming weeks as we lead up to the Best Practice Forum. So any thoughts and ideas are very welcome. Just, I guess, to cover off then on housekeeping, we'll send a recording of the session to everyone who has registered, and when we have a date confirmed for the next webinar, we will also send that to you as well. But otherwise, I have shared other ways that you can keep in touch with us online, Twitter, LinkedIn, and via the website. So hope to see you at the next webinars or through the Best Practice Forum next year. But thank you again, Daniel, Lucy, and to Richard for chairing.
Right, well, I don't know where that leaves, but I think that's it, and we're running to time. And just my thanks again. I don't know if any of the other Roots to Justice team want to say anything, John or Susie, in the 1 minute we have left, but John's shaking his head. So thank you again, everyone. And we look forward to this being the start of or a continuing exchange and relationship. And so that's, I think, goodbye from all of us for now.
Thank you very much, all.
Thanks very much, Richard and John and everyone. Thank you, and Emma.
Thank you.
Thanks, Lucy.
Bye.
Bye, everyone.
Bye.